Your Lordship, the lead counsel is out of station today due to his father's illness, so we seek for adjournment for the day.
Where is Mr. Mr. Majumdar? Where is Mr. Chutia?
I have not seen him.
He was supposed to produce the records.
Yes, Your Lordship.
Let's make a phone call, my lord. I'll try to press out please.
Anyway. No, MS.
K. Bhattacharya.
K. Bhattacharya, Learned Counsel for the Learned Counsel appearing for Mr. Are you for petitioner?
Yes.
Learned Counsel for the petitioner submits the leading counsel, the learned leading counsel in this letter. The learned leading counsel in this letter is out of the station. Therefore, she prays for the adjournment of the matter. Praise the Lord. List this matter after 3 weeks. 3 weeks.
It can be listed next week also, Your Lordship.
After 2 weeks. Next matter. This court on 28/10/2024 directed the learned additional senior government advocate Mr. T.C. Chutia for production of the records. However, he is not the Mr. Who is for this? Anybody appearing? You just inform him.
Okay.
Since Mr. Armajumdar Learned Counsel is present, he is requested to inform Mr. T.C. Chutia regarding the order dated 20/10/2024. Just after 2 weeks, released from the partner. Oh, I'm releasing from the partner.
Yes, Your Lordship.
No use keeping it partner.
No.
Since the mission, although the matter is shown to be partner, prayer of the Learned Counsel for the nation of same released from the partner. Same is released from the Yes.
My lord, I'll appear on behalf of my lord.
These all are same advertisement.
Same advertisement.
Same advertisement.
My-
All for repetitions.
For all respect.
All repetitions.
Same
advertisement.
Same. My lord.
And appointments are on different dates.
No, yes, some of 2-3 days in different, but so same my lord.
Out of one advertisement.
Yes, same one advertisement 13/12/89 somebody and some 19/12. My lord, same December. Within December, all are appointed. My lord.
Yes.
My lord, already all points are already heard. And now, my lord, your lordship is last occasion, my lord, want to file affidavit, my lord, and I have reply, my lord, and we have filed reply, my lord. My lord, in my reply, if your lordship go to it, my lord.
Yes.
My lord, read petition number, my lord, 9573 of 2019, my lord. 9573 of 2019. Your lordship.
First read petition.
9573.
Yes, yes.
My lord. But in this case, my lord, though we have appeared, my lord, and page 270, my lord. My lord, para 5, my lord, 269, my lord, para 5, my lord.
Yes.
May I read? My lord? That with regards to statement made in paragraph so and so of the affidavit in opposition filed by the respondent number 1, the apostate read petition same are matter of record. Deponent does not admit anything which are contrary or inconsistent with the record. Deponent further begs to state that after verification of the report submitted by the committee constituted by the respondent authorities, the report of the committee was not been furnished to the incoming concerned. Though the scanning committee was constituted for examination of cases of illegal, irregular appointed teacher and verified applications submitted by the applicants by the divisional scanning committee and submitted their report to the government, but petitioner were not provided any opportunity to place and clarify their cases before the divisional scanning committee. That with regard to the statement made in paragraph 12 of the affidavit of the filed by the so and so, the deponent begs to, though the scanning committee submitted the report, but respondent authority have not served the copy report, so thereby petitioner on reply against scanning committee. The details retired and non-retired teacher out of the petitioners are as follows. We have the chart maybe given next page 270. My lord, out of my lord, 13 petition, 14 petitioner, my lord, 7 petitioner already retired. My lord, first, my lord.
Rest, still continue.
And list of not retired, these are the non-retired person. And 1 petitioner was expired, serial number 7, my lord. The Resinda Hazang expired on 8/3/2022, my lord. Next, my lord. Next page 271, my lord. Out of 14 number of read petitioner, 11 number of read petitioner have joined as accommodated teacher. 11 number of read petitioner have joined as accommodated tutor, out of which petition number 1, 2, 5, and 12 have retired. Petitioner number 3, 4, 6, 8, 13, and 14 are in service. 3 number of read petition, that is petition number 7, 9, and 10 have not received the appointment of accommodated tutor, as they have attained the age of superannuation before they were appointed as accommodated tutor. And 1 petitioner, that is petition number 11, had expired on so and so. Next, my lord. That with regard the statement made in paragraph 13 of 14 of the affidavit of opposition, the respondent number 1 by apostate read petition, deponent categorically denied the same and further begs to state that the alleged termination letter were never served to the petitioner at any point of time. The district elementary education officer filed letter dated 25/2/2008, annexer M, page 129 of the petition, my lord, clearly mentioned that 44 number teacher appointed 89 under block elementary education officer Bordolli were not terminated, and there is no official record DI school Dhamazit that they were terminated. There is no double appointment against the single post, and all appointments were non-plain posts. The said 44 number teacher include the present petitioners. Therefore, the allegation made against the petitioners as terminated teacher does not arise. In spite of specific order from Honorable Court, respondent has not mentioned the date of receipt of the termination order that were ever served to the petitioner at any point of time. This is their stand, my lord. Next, my lord. That with regard the statement made in paragraph so and so affidavit filed by the respondent number 1, the apostate deponent most respectfully beg to state that appointment order were issued by the competent authority against sanctioned vacant post after due process of selection. Petitioner cannot be terminated from their service without following procedure prescribed under so and so. If the petitioner were terminated from their service in the year 1992, then why the respondent authority extended their service till the date of their superannuation? as well as till today, and why the authority accommodated them as a tutor. Therefore, allegation of termination of the petitioner in the year 1992 is not at all sustainable as per law. Next slide. That with regards the paragraph 20 of the affidavit of opposition filed by the respondent number 1, respondent Bektu states that they have not received due monthly salary August 2007 in spite of discharging their duties regularly without any break. Under compelling circumstances and finding no way out, considering the fact that the phase accommodation will serve the petitioner and their family from starvation, and with a hope that they will get at least the fixed monthly salary which will help in maintaining their family, since they have not received any salary August 2007. As such, they joined their accommodation post pursuant to the order dated 31/2021. Deponent further begs to state it is a settled position of law that where there is any unfair, unreasonable, or irrational clause in a contract, it is also unjust, and same is amenable to judicial review, and Constitution provides the achieving social and economic justice. Article 14 Constitution grants it to all persons equally before law and equal protection of law. Thus, it is necessary to strike down unfair and unreasonable contract or unfair, unreasonable clause in a contract that has been entered into parties who do not enjoy equal bargaining power, and hence hit the section 23 of the Contract Act, and where such condition or provision become unreasonable, unfair, further is against public policy. In the present case, accommodating petitioner as a tutor by imposing an unreasonable clause of debarring the petitioner for claiming past service is unreasonable, unfair, and is against the public policy. Therefore, claim benefit whatsoever in respect of past service rendered by the petitioner prior to 1/11/2020 cannot stand scrutiny of law. Therefore, Honorable Court may be pleased to allow the petitioner to arrear and salary with effect from September 2007. Petitioner respectfully begs to state that Assam, the state of Assam representative commissioner, secretary, government of Assam, elementary department, other filed a writ appeal before the division bench, being appeal number so and so against the order dated 22/1/19, passed in WPC number so and so, whereby the learned single judge disposed of the
Why you are
petition.
relying this?
Relying this the same my lord issue. A scanning committee, they were appointed, not given salary from 2007. Thereafter, scanning committee, they are appointed as a tutor. Same. Thereafter, same
advertisement.
Thereafter, what happened, my lord? Honorable single
You were
bench.
appointed in.
I annexed this, my lord.
You were appointed in
In 89, my lord.
89 or 99.
99.
99, they are in
There's a
99 or
difference.
89, my lord.
That's why I'm asking you. Is this the same out of same advertisement? This.
No, tutor is as a tutor in 31 1
No.
2000.
The order which you are relying.
Order relying, my lord.
Division
annex-
bench.
Division
Is
bench.
it the same advertisement?
My lord is the 99 day appointment. 99.
What about you?
Our 89.
That's what I'm saying. That's why I'm
But
asking.
they are in. They say that they are illegal. Thereby they are stopping salary. Thereafter, my
It's a
lord,
different case
but the same
altogether.
scanning committee, they were appointed as a tutor. We are also same day. We are in accommodated as a tutor, my lord.
No, see, first is your case in 95973 is for payment of salary.
My lord.
Have you not been paid salary
My lord.
till your retirement?
Somebody was retired and
No,
somebody.
till when you were not paid. This matter was filed in 2016. No.
No, my lord. Initially, we are in file, my lord, in the year, my lord.
2016.
No, 2016 for non-payment of salary.
Yes.
Thereafter, they annexed some termination order.
So you have filed this 2019.
Yes, my lord, challenging the termination order. my
Okay. So then other two petitions.
lord. Other two, I don't know.
So first, up to which year you have been paid the salary?
Up to 2007, my lord.
Thereafter, no
I'm
salary.
not receiving. We are
Till
not
retirement.
till retirement. No, thereafter they are accommodated. Somebody accommodated and receiving 10,500 per month.
When it was accommodated
Accommodate, my lord.
as a tutor.
He has a tutor, my lord. 90. কেতিয়া কৈছিল accommodate? 20, my lord.
2020.
Yes, my lord.
So
31, 2020. 31,
So
2021. We are
2007 to 2000.
we are paying for arrears.
So you have not been paying.
No, not.
How do you survive? How did you survive?
Because of that, my lord, actually, my lord,
2007 to 2020.
Yes, my lord.
Till you were
So we are in the
accommodated.
verge of retirement. Our sons is also there, and there is some cultivation. And from 9 a.m. the class was started. We are in the morning go to the field, my lord, paddy field. Because of this is the fact, my lord.
These are all strange things.
This is the fact, my lord. They cannot state that we are not working from 2007. Nowhere mentioned that we are not working from 2007. Why they expected our services? My lord, division bench, honorable court, my lord. Please may kindly see.
It's okay. I've seen it. But facts remain.
My lord, paragraph 2 in the judgment, my lord, division
I've
bench.
seen it.
My lord, April, they are paid salary pursuant to a requirement in 2006, and thereafter they were not receiving salary. And thereafter, after scrutiny committee, they were accommodated as a tutor by giving the 10,800. We are also 10,800. And honorable court set aside the tutor order. Why? The honorable single bench dismissed the petition. Thereafter, my lord, allowing the petitioner, my lord, government go to the division bench. And division bench, because of they say their stand is that we have given the accommodate, and there is some condition you cannot receive it the prospective, not, my lord. So
No.
thereby they were, my lord, go to the division
So
bench.
what relief
Relief, my lord,
you are expecting?
we are expecting only, my lord, we are going already retired. And regarding, my lord, retirement is concerned, my lord, that is the another focus, my lord. Okay, another, my lord, issue, my lord, because whether in new pension, old pension is that is different, my lord. But one thing is that area salary we have to pay, my lord.
As a regular teacher.
As a regular. So from 2000 till to September 2000, August 2007, we are receiving a regular time scale of payment. Which scale of payment?
Till 2007.
2007. So that we have to pay. My lord, division bench says that. Please may kindly see, my lord.
It's okay. Forget it.
My lord, I am not going to in other things. At least, my lord, we have to.
No, facts remain that you are issued a so-called notice.
So cost.
You have replied.
Reply, my lord, but as per record, they say that we have replied. But they did not earlier. They did not.
No, it's
Yes,
on
sir,
the record.
but this our stand is that till
You have not disputed this.
yes, sir, but we have not received any termination or specific as well as
No, that will come later.
no,
We'll come to that.
there.
You just clear that first.
Yes, sir.
So-called notice was issued.
Yes, my lord.
You have
Not only that notice, my
You have
lord. 2001 also they were issued so-called.
It's all right. You have replied.
So many so-calls they are issued and again and
Anyway,
again.
you have replied to that.
Yes, my lord.
The only issue is whether you have been served with the
Termination order. If there is record is there, we have received termination
So,
order.
there was
My
a
lord,
direction of the
so
court.
many Supreme Court judgment, the
No,
internal
it's okay.
routine cannot
There
be
was a
treated as
direction
committee.
of this court
My lord.
to produce the record, whether or to clarify whether the termination order was served on you or not.
My lord,
That is
because
the
of that,
draft only.
my lord, if honorable court permit me page 129 of the petition. That corroborated by their officers that says that we are not terminated.
One,
Page 129. This letter was issued by the competent authority, that is the District Elementary Education Officer Dhemaji, my lord. Please may kindly I read this. This letter, my lord, on 2008, after stopping our salary, they give the communication 25 to 2008, my lord. May I read, my lord? Regarding release salary in respect of so and so under block and so and so. With reference, you also got it, my lord. With reference to the subject cited, I have the honor to furnish below details report in respect of release of salary 44 numbers of teacher under block elementary education of board only for favor of kindness. In the letter mentioned in application so and so dated so and so in first paragraph, 44 number teacher appointed, 89 were not terminated. Your Lordship got it, my Lord?
Yes.
They will not get sick. Those who are terminated in the year of 1992, my Lord, they have given sick amount, my Lord. They will not get sick. They have been receiving their monthly salary regularly. There is no official documents as they were terminated, my Lord. In second paragraph, appointment all teacher genuine, receive salary regularly. Next page, my Lord. There is no doubt appointment against post. All appointments were against non-planned post. In this case, I would to furnish following information. There is record of issuing termination letter 44 numbers of teachers, but in office there is no record of the receipt of those letters by the teacher.
Okay,
So
just wait. It's just mentioned about 44 teachers. It doesn't indicate your name.
yes, our name is there, my Lord.
Where
Please
it
make page 136, my Lord.
136. It's a part of this
Record, my Lord.
a
List
part
of
of this letter.
letter, my Lord. Yes, my Lord.
136.
Yes, my Lord. Our name is 136, serial number, petition number 8, Siri Mohini Fukon, petition number 5, Ekon Pegur, my Lord. These are the petitioner 12, 14. Yes, all are there, my Lord. Noren Hazarika, petition number 3, serial number 33. Niru Borua, petition number 10.
14.
Yes, Kanti Soika, petition number 39. Petition number 1. Petition number 1, serial number 39. Your Lordship got Kanti
So
Soika.
it's all 14.
All 42 mile, 44 mile, 42 mile. And thereafter, my Lord, page 137.
You are 14 petitioners.
Mile, only 14 mile.
14.
Then, my Lord, all others are receiving and they are retired peacefully, my Lord.
Yes, they are saying 42, 44, but the total list is 42. Here.
Did not receive check for their working period, my Lord. Before my Lord, termination, my Lord, they given a check, my Lord. 6 month salary, my Lord. And next page, director return letter, next 137. 137, your Lordship.
Is this part of the document, the annexure of this letter?
Yes, my Lord. My Lord, my Lord, please may kindly say page 137. my
It
Lord.
doesn't show, sir.
Page 137, your
This
Lordship.
is something different.
My Lord, page 137.
133.
Was 133. Yes, my Lord, this is the letter, my Lord.
What does it say?
Go. My Lord, 137 is the director letter, my Lord, your Lordship. Go to it, my Lord. 137, my Lord. This was issued by the director to the Commissioner Secretary Government of Assam Education Elementary Department, release of salary in respect of Bitu Borua and 41 numbers. This letter is first Bitu Borua, my Lord. Bitu Borua and 41 numbers, my Lord. This letter, my Lord. With reference to the subject cited above, I have the honor to enclose here with a report submitted by the DO, Dhemaji Bhait, his letter number so-and-so dated 4/10/2004 necessary. In this connection, a report has already been submitted to the government stating the fact Bhait office letter number so-and-so, copy of which enclosed here. The DO Dhemaji submitted Bhait's letter number so-and-so 4/10 to the copy enclosed, stating that 42 numbers of LP school teachers under BO board only out of 44 were not terminated and did not receive check for 29 months their working period. In this connection, it may also be mentioned in that 44 teachers, there were 2 numbers of teachers, Renumai Borua and Divajani Gogoi, are found in the check payment register as reported in DO Dhemaji by letter number so-and-so. This is the letter, my Lord. And my Lord, my Lord, respectful Permission before Lordship. Entire all facts, your Lordship already know, my Lord. Only if our termination order is received, any office record is there, I have noticed. I cannot say. But the Honorable Division Bench says that you cannot put a condition for as a accommodate teacher. You cannot receive in earlier past service. This cannot. So thereby Honorable Division Bench set aside this order.
But why you have accepted this?
This is they are also accepted. That order
No,
also
no,
accepted.
no. You have accepted the tutor post
My Lord.
gracefully. You have accepted on your appointment.
Yes, my Lord. This,
As a
this is the we have no bargaining power because of it. Khanapara more than
Just
10,000.
because the Supreme Court says so, you cannot take that plea. When you were 2020,
Yes, my Lord.
you have accepted the.
There, your Lordship, if
Most
you
of
give
the-
me time, my Lord, I will give the judgment. There is no estoppel to challenge before the Honorable at any time.
You have not challenged.
Because of this pendency
Have
is
you
there.
challenged that?
Pendency is repetition, my Lord.
Sir,
And that stand was
Sir,
taken by
sir,
the
sir.
that stand was taken by
sir,
the
please listen first.
my Lord.
You have not challenged the appointment as a tutor.
My Lord.
Just because Supreme Court says so, you're just going to bring up those points. It's not your case. Your case is you're regularly appointed and you have not been terminated. So why you have not been allowed to continue? I mean, why you have not been paid the salary? That's your simple prayer.
My Lord. Well, our
Now, in during the pendency, you have accepted as a tutor. You have not challenged that. You have gracefully accepted, happily you have accepted the post.
that by the queries, that query is taken by the authority before the division bench. And division bench also no.
I'm not concerned about division bench. Law may be there.
My Lord. Then, my Lord, two judgments I have not taken today. Two judgments is there. First judgment is Supreme Court, my Lord. I will give you that one. First, there is no those situation. There is no
You have
bargaining.
two judgment.
Yes.
I'll give you 100 judgment.
Yes.
On
Those there is no any bargaining power because of that they are the
That's
authority.
why I'm saying I'll give you 100 judgment.
Yes. Sir.
That's why it's not the issue here.
My Lord, so, my Lord, my prayer is that, my Lord,
This is not the case in these proceedings,
my Lord.
in these writ petitions. Your simple case is that you have been regularly appointed, but then you have not been paid. Now they have come up with an when you challenge that non-payment of salaries, they have come up with the documents that you have been terminated.
My Lord.
Now, subsequently, by this second attempt to, 3, you have challenged the termination that you have not been provided with an opportunity. There is no termination order. You have not been served with. Then the issue we are considering. So, all along, what we have asked the government is to produce the record.
My,
Whether you have been served with the copy of
Termination
the
order.
termination or not.
my Lord, this is the
Whether due process has been. That is the
My-
only issue.
my-
Why bringing all those tutor
yes,
and
my-
all those things?
so, my Lord, I am
Now,
only
on the other day, what this court was of the view that since you have accepted the tutor post, I mean, as appointed as a tutor, why don't you continue on that and forget it? That was my view. Now you are not interested in the tutor post, though you have accepted. But in these proceedings, perhaps you cannot take the plea of some this bargaining power and all this.
yes. We have to put
That will not consider.
I am praying before Lordship. We are already retired. Some of the persons is going to retire by 2-3 months, my Lord. So I have based your Lordship. I have the my Lord only my Lord prayer
This
before
is the
Lordship.
this is it is by you only you have delayed the matter.
No, I
It's
have
been
not
dragging
delayed
it
the
for,
matter because of that. Because of that,
2-3
that
months.
petitioners are retired, so they are not coming. So how can I file reply, my Lord? Because of that, due to their retirement, they have some ailments are there. Now sometimes he has due to my pressure from me is coming and file. At least at best from 2016 we are continuing these proceedings. But at best at the end of justice, I cannot say other, my Lord. You have to pay because of that. That division bench order given the all salary along with my Lord. If honorable court was judgment, my Lord, last your Lordship, the division bench, my Lord, order, my Lord.
No, I have seen that. That I have seen already.
That
And
fresh
then
appointment
one
of the
more-
tutor
one
order
more-
that cannot be sustained. But that tutor was not challenged, my Lord.
You look, huh?
that judgment tutor was not challenged by the petitioner. Honorable court directed to pay, and thereafter they challenged by saying they accepted the accepted the tutor, so thereby they cannot claim. So thereby division bench said no.
No, it's not the case here. Is it your case here?
Because of that, well, that,
No,
that
is it the case here?
in my affidavit also praying
I
that
have indicated you on the other day.
Right.
This court was of the view that since you have accepted, why don't you be happy with the tutor post? That you are not interested. But then it's not an issue whether you have accepted it or not.
issue is regarding
It is just
termination.
prior to that.
My
We'll look into that.
my
We'll
lord,
examine
as
it.
your lordship, my lord.
Yes.
This is my humble.
Our case was one of
Yeah, humble.
suppression of material facts before this honorable court, even at the institution of the case. If lordship should kindly have the writ petition, I'll just. Para 14 of the writ petition was very specific. They did not receive the notices. They did not receive any show cause notice. It was very specific.
There are 14.
That earlier proceeding is there, same my lord, or proceeding.
Let's we'll see.
Lordship means
Yes.
para 14, fourth line from the top, showing any reason. The petitioners at no point of time have received any show cause notice for termination till date in connection with their service. Just stop here for a moment. Now, when the salary of the petitioners was stopped in the year 2007, this writ petition coming up in the year 2019, the petitioners had actually approached this honorable court on an earlier occasion by WPC 5635 of 2007, which they have themselves stated in their writ petition. Which lordship should find at page 139. This is an earlier occasion, my lord.
Which page?
Page 139, lordship should have.
Same.
Same petitioners,
1.
39 of the writ petition. Same writ petitioners with the same grievance that we have not been paid from August 2007. Their lordship should kindly have the operative part of the case, order, my lord, page 142.
This way.
Page 143, I'll read from the second paragraph from the top. The petitioner's claim.
Just wait. Page
143 is what I'll read. Second paragraph from the top.
yes.
The petitioners claim that they were initially appointed, lordship finds at the top, in the year 1989 as assistant teachers of LP schools after going through a proper selection process like written test and viva voce. Accordingly, the petitioners have been serving as assistant teachers in their respective LP schools without any interruption. The petitioners also claim that since they were regular employees, they were allowed to open GPF accounts and increments were also given to them from time to time. However, to the shock of the petitioners, their salaries were stopped from August 2007 without any notice and state that they were never informed about the authorities that they have been terminated from the service as contacted by the respondents. Accordingly, petitioners have approached the court challenging the aforesaid actions of the respondents, which the petitioners claim are illegal as the authorities cannot block the salaries of the petitioners without terminating the services in accordance with law. Then lordship should find at page 144. The third, the second paragraph from the top, Mr. Seki.
Just wait. Yes.
On page 144, third paragraph, my lord, Mr. Sekia, learned counsel for the petitioners. However, strenuously contends that in spite of the aforesaid averments made in the affidavit, that was the affidavit of the respondent, the fact remains that they were never served with any show cause notice or any termination order because of which they continued to serve till date. Therefore, in view of the rival contrary contentions, a disputed question of fact has arisen as to whether the petitioners were indeed terminated from their services as contended by the state respondents in the year 1992 after issuing show cause notice. Therefore, this aspect needs to be first verified by the authorities concerned before any consequential order can be passed. Accordingly, this court is of the view that it will be appropriate for the state authorities to make an inquiry as to whether the petitioners had actually been served with the termination order as stated by the respondents, and if it is found that the petitioners had been served with the termination order, obviously the petitioners have no right to serve after the termination orders were issued to the petitioner. Accordingly, they would not be entitled to any salary. But however, if such termination orders were indeed not served on the petitioners, and if they continue to serve as claimed by them, they will be entitled to get salaries for the period they were rendered their services. Now, therefore, in view of the above, the authorities will examine the case of each and every petitioner, whether they have been served with show cause notice for termination or the termination orders, and if it is found that no show cause notice or termination orders have been served to them, they will be entitled to get the salary for the services rendered by them as given to them for the period from December 1989 to May 1992.
But it is wrongly, my lord, typographical.
Let us do not go by the dates.
Typographical, pair is 2007.
Now, my lord, even in the year 2012, when this repetition was disposed, repetition of 2007 was disposed of, the vital issue which was before this honorable court, which was vehemently refused by the petitioners, was that there was no show cause notice prior to termination or any termination order. Consistent stand taken by the petitioners herein is that we were not given the order any show cause notice prior to our termination. Lordship has seen the paragraph at the statement at paragraph 14, which they say that we were never served with any show cause notice. Thereafter, Lordship would find that we brought on record the show cause notice, my lord, which was at page 163. I'm sorry, my lord, that was the termination order. At page 163 is one of the termination orders. Lordship finds the type copy is at page 162. It reads, my lord, the reply of the show cause notice submitted by you has been examined and that your reply is not satisfactory. So while bringing this on record, the petitioners were then made to know that you had given a show cause, a reply to the show cause notice. We did not find it and we terminated you. So even at that point of time, the petitioners had the opportunity to say that we received a show cause notice, we replied to it, we did not have an order of termination. But in this present petition filed in the year 2012, which is not wrong, in the 2019 is the one that I'm holding, Chandreswar Saika. Even in 2019, they say we have not received a show cause notice for our termination. Now, look, in another litigation which is before Lordship, it is in the year 2016. Then also we said you had a show cause notice, you had a reply, we gave you a termination order. Even in the 2016, they said we have not received a show cause notice. In 2019, they say we have not received a show cause notice. Now, my lord, we file an affidavit which Lordship will find the most recent affidavit, my lord, filed on 29th of August 2024. Here, my lord, at page 18, I make a specific averment again. The most recent affidavit, Lordship. At page 202 running, if I'm not wrong. Starts at page 193. I'm reading page 202, para 18. The answering deponent humbly begs to state that the petitioners in reply affidavit to the affidavit in opposition filed by the Director of Elementary Education in WPC number 3288 of 16 stated in paragraph 6, a part of which is quoted below. The deponent specifically denies that neither the show cause notice for termination nor the termination orders were served to the petitioners at any point of time. The above statements made by the petitioners are contradictory and false in as much as they have not only received the show cause notice but have also submitted their show cause replies to the show cause notices, and admittedly the termination orders were also duly served upon them after following the due process law. I am still leaving aside the part of the termination order. We have not been able to produce a register showing that this was, but the other part of it. Did you receive a show cause notice? Did they receive it? They say no. On affidavit, they say no. Repeatedly, they say no. We bring on record their replies, and today it has been admitted that yes, we received the show cause notice. We filed a reply to it. Now, my lord, the affidavit reply, which was now read out by my learned senior friend, my lord, that affidavit, if lordship will see the reply to para 18. I'm sorry, my lord, of the same affidavit that I was reading, the earlier affidavit, para 20 also I would like to read, my lord. Para 20 of this. The answering deponent further begs to state that the petitioners accepted and joined their respective schools in terms of the order of accommodation dated 31/2021 in the year 2021 itself, accepting all terms and conditions without raising any grievance at that time of joining and after filing of the writ petition during their pendency. It is stated that it was a conscious decision on the part of the petitioners to have joined pursuant to an order of accommodation dated 31/2021 without raising any grievance, which is reflected from the fact that the petitioners joined after issuance of the order of accommodation on 31/2021, and therefore they had enough time to reflect on the effect of accommodation. So, if we come to the affidavit in reply at page 272, where I had made an allegation at paragraph 18 of my affidavit in opposition that they have received a show cause notice and they replied to it. How they deal with it, madam? How they avoid the issue? And therefore, I say this is an attempt to mislead, to suppress material facts. With regard to the statements made in paragraph 15, 16, 17, 18 is the relevant paragraph of the affidavit in opposition filed by the respondent number 1 in the aforesaid writ petition. The deponent most respectfully begs to state that appointment orders were issued by the competent authority against sanctioned vacant post after due process of selection. The petitioners cannot be terminated from their service without following due procedure prescribed under the Assam Discipline Appeal 1964. If the petitioners were terminated from their service in the year 1992, then why respondent authority extracted their service till date after this of their superannuation as well as till today, and why authority accommodated them as tutor? Therefore, allegation of termination of petitioners, my lord. Not one word saying that we are sorry. We received a show cause notice, we replied, it went out of our minds, we did not think it material to be placed before this court. It is a matter of record which could be produced at any possible point of time, therefore it is not suppression. No. My specific allegation on the further respondents being that you are hiding a very material fact. When you say that I did not know of my termination, you received the notice, you replied to it, we terminated you. Affidavits upon affidavits, writ petitions supported by affidavits saying that, sir, I did not receive any notice. Now, what, if I may be allowed, my lord, what is a material fact which, if suppressed, would perhaps.
When is there show cause? Where is
Show cause
there
notices?
reply?
Show cause, yes. If lordship would have the WPC number 3288 of 16.
In your affidavit.
In my affidavit in opposition in 3288 of 16. There are two affidavits there. One is filed on 10th of April 2023. The additional affidavit in opposition. 18 April 3288. That would be running page 180 onwards.
Additional affidavit.
My lord.
Yes.
My lord, in this particular matter itself, if lordships would have the first affidavit filed on 23rd of February 2017. 23rd of February, my lord, the running page, I'm extremely sorry, my lord, it is not paginated at my part. At that point of view. 23rd February 2017 in 3288.
What is there?
Filed by Sanjeev Kumar Bhia.
No, what is there? Why? What is the additional affidavit?
But additional affidavit was after we brought on record the termination orders.
Hmm.
Then after they filed a reply, then this honorable court told us that if you have copies of the show cause notice and the replies, bring them on record. Then we file this additional affidavit. So Lordship will first take the other affidavit, my lord, earlier affidavit of 23rd of February 2017.
Page
Okay, running page is difficult. Repetition of page number
30th March. 30.
23rd February 17 is the filing assistant. 30 is their reply. Just prior to that, it will be there. About 20 pages before that. By one Sanjeev Kumar Bhiya, my lord.
Yes.
Huh? Correct. Now, this Sanjeev Kumar Bhiya's affidavit, Lordship will find at paragraph 6. Paragraph 6, my lord. The deponent begs to state that in compliance of the Honorable Court's order dated 27/4/2012. My lord, this 27/4/2012 is the 5635 order which I just read in the other petition. The office of the deponent had examined the case of the petitioners and perused the report submitted by DEO Dhemaji via its letter so and other relevant records and documents. The DEO Dhemaji reported that show cause notices were issued to the petitioners during March 1992 before termination, and they had submitted their replies during April 1992. The replies submitted by the petitioners were not satisfactory and they were appointed illegally against non-existent posts. Considering all aspects of the matter, this director by letter dated so rejected the claims of the petitioners for payment of salary as they were terminated from service in the year 1992. Copy of the termination orders in respect of petitioners submitted by the DEO is annexed herewith. Now, Lordship would find that at the page 7 onwards. Lordship will find these are the orders, page 7, 8, 9, 10, 11. These are all orders of termination. We brought on record. They filed an affidavit in reply to that. Of that affidavit in reply, which was filed on 30th of March by the same Chandreswar Saikya, Lordship will find at para number 6. Page 3, para number 6 of the affidavit filed on 30th of March 2017.
Yes.
That as regards to the statements made in paragraph 6 of the affidavit in opposition filed by the respondent number 2 in the aforesaid petition, the deponent begs to state that the deponent specifically states that no show cause notice were ever served on any of the repetitioners, and none of the repetitioners had submitted any reply to the alleged show cause notice. The document annexed with the affidavit in opposition by the respondent number 2 at page number 6 clearly shows that there is no date of service of the alleged termination order to the petitioners. Documents annexed with the affidavit in opposition filed with the respondent number 2 at page number 7 to 19 are issued under the same memo number 704043 dated so and so. The said alleged termination letters were never served to the petitioners at any point of time. Impugned order passed by the director is without examining each and every case. I'll go back to the first part, my lord, again. Deponent begs to state that the deponent specifically states that no show cause notice was served to any of the repetitioners, and none of the repetitioners had submitted any reply to the alleged show cause notice. Therefore, my lord, what had fallen from Lordship just now, why the additional affidavit? Now, if Lordship has the additional affidavit which starts at page 180,
Yes, absolutely.
their Lordship will find at page 192. Was the order of this court to bring on record whatever documents we have regarding the termination of the petitioners, and from page 194 onwards, Lordship will find page 194 is a notice to Kanti Saikya, who is the repetitioner. We say that you were the handwritten black part is the memo numbers and all. You had appointed under the memo number is given, date is given at the top. It's overwritten. Issued by D. Gogoi so-and-so irregularly without verification of particulars and in violation of so-and-so. You were not selected candidate against vacancy. You are directed to show cause within 15 days from the date of receipt of this order why your appointment should not be cancelled. This lordship will find is at 33/2/1992 at the top. This is the date of the show cause notice. Now lordship will find a few pages later at page 208, typed letter of 10/4/1992, just near the date, vertically it is written Miss Kanti Saikya, and she writes reply to show cause notice dated 30/3/1992. In pursuance of your show cause notice issued above, I most respectfully beg to submit reply against show cause as under. The show cause notice is itself arbitrary and self-contradictory and against the rules. I have been appointed as assistant teacher of so-and-so by the NDIF schools. Then third paragraph she says, I have drawn my salary from 31/12/89 to from 13/12 to 31/12/89 on 6/1/90. That I have not received my pay and allowances with effect from 1/1/90 to 34/1991. This she is writing on 10/4/1992. Then she says that I have been paid my pay and allowances for the month of May and June 91 without getting arrears. That I have been transferred from Gosaibari to so-and-so. That my pay and allowances are made regularized by block officer by this order number so-and-so dated 21/3/92 on the basis of order of so-and-so. Moreover, the assistant teacher who were appointed with me by the same selection list have been enjoying pay and allowances. They are, then she names a few teachers. Then she says, to my utter surprise, I got a show cause notice on 30/4/1992, asked me to give reply about my appointment. I am not responsible for any official act done by the school authority. I have been duly selected as a teacher by the competent authority.
This reply is of which month?
This reply is at page 208, lordship will find, just below where I have written annexure 16, lordship will find dated 10/4/1992.
Then how can the notice be of 30th/4?
Madam?
Can the notice be
34/1992.
Yes.
I'm sorry, this is the 10/9, I suppose this is 10/9.
That's what I'm asking.
It is her handwriting. I'm just trying to read the handwriting. It has to be 10/9.
Then termination.
The termination order, lordship, termination order is then. These were the show cause notices. Yes, termination orders are here also. Yes. Okay. Yes, lordship will find it page 231. 231 for this particular petitioner. It is at 231. And it is the typographer, Mrs. She has written 30/4/1992 at page 209. It has to be 33/1992. The show cause notice was of 33, not of 34. That is her typographical mistake. The petition was at page 209.
Yes. You
So
have
number
issued, there is
my-
no dispute, but issue is whether this has been served to him. or
My lord, that is one part of the issue. Which the termination orders I have made a statement again and again. Their signatures on a receipt copy we do not have. That is admitted position. I'm not.
We'll examine that.
But one thing that
No,
lordship
what
has
you
to
are
say-
saying is there's a separation of material facts.
very material
saying
fact.
all along there that they have not been issued a so cause notice.
and
Whereas
they did never
have been
reply to
issued,
it
They have replied to it. Up to that, I agree.
because
And the fact remains that the termination order was issued.
yes.
The real
Now-
issue is whether that has been served on them.
Now that is what I was coming
According
to. Lordship
to
will give me
Yeah.
one opportunity. A person who on record has received a show cause notice has replied to the same. on affidavit swears to say that I have not been. Once we produce the termination orders first, they say this is a termination order. I never received a show cause notice on affidavit. I never received it. I was not given an opportunity.
Yes.
Then we come on record to show that look, sir, you had it and you replied to it. In their reply affidavit, they do not speak one word about that. Meaning, the moment we cannot produce something, they get an inkling that I cannot produce something is the hinge they take to say that I was not given a copy of the termination order. Given the attitude of the petitioners, when they have made false statements before this honorable court, would the honorable court, my lord, in my humble
It
opinion,
doesn't matter.
whether they can be relied upon to say that they never received it?
So they are not entitled for any relief.
Article 226 extraordinary jurisdiction, my lord, in this case will not be exercised, and more so in the view of the fact that during pendency, when I insisted that they have been accommodated, persons have died, not brought on record. I'll just refer to one judgment, my lord, if lordship could have it. I'll not read out to make it tedious, my lord. I had given the citation. Here, my lord, the state was at the receiving end. 2008 4 SCC 127. The state was at the receiving end of this, in this particular judgment from Punjab and Haryana High Court. The Supreme Court, my lord, has referred to a case from the Guwahati High Court also. Lordship will find that paragraph 12. Suppression of material fact, lordship finds. Just below paragraph 12. We fail to understand is how it starts, my lord. We fail to understand how even in a case of dismissal where the state pretended to be so serious in obtaining a principle of law determined by this court, such a delay took place in filing the writ petition and also the special. Suppression of material fact is viewed seriously by the superior courts exercising discretionary jurisdiction. In so and so, this court on suppression of fact held. As a general rule, suppression of a material fact by litigant disqualifies such litigant from obtaining any relief. This rule has been held out of the need of the court to deter litigant from abusing the process of court by deceiving it, but the suppressed fact must be a material one, in the sense that had it not been suppressed, it would have had an effect on the merits of the case. The said observation was quoted with approval by one of us in Arunima Barua versus Union of India, wherein the question which was raised was how far and to what extent suppression of fact by way of non-disclosure would affect a person's right of access to justice. The court notices that so as to enable it to refuse to exercise its discretionary jurisdiction, the suppression must be of material fact. What would be material fact? Suppression whereof would disentitle the appellant to obtain a discretionary relief would depend upon the facts and circumstances of each case. Next one, in recently so and so, the High Court in exercising discretionary and extraordinary jurisdiction under Article 2 of the Constitution, over and above a court of law, is also a court of equity. It is therefore of utmost necessity that when a party approaches the High Court, he must place all the facts before the court without any reservation. If there is suppression of material facts on the part of the applicant and twisted facts have been placed before the court, the writ court may refuse to entertain the petition and dismiss it without entering into the merits of the matter. Had the aforementioned facts brought to the notice of this court, the special petition might have been dismissed summarily. Even delay in filing the same might not have been condoned. The court was not required to waste so much time if the state had in itself, for intent, accepted the award. Why I am stressing on this is, my lord, 2007 the salaries are stopped, as they allege. 7, they are reminded that you had a show cause notice, you had a reply, we terminated you, don't lie to the court. They underwent a verification process with us, came back to this court in the year 2015, 16, 17, 18, 19, even in 21, to say we don't have a show cause notice. We don't. If this honorable court was informed that there was a show cause notice and there was a reply to it, perhaps the entire, my lord, direction of the court would have been a different thing. Here is a case where the petitioners try to impress the court without anything. I am thrown out, sir. And then I come to show you had these documents, and yes, sir, I apologize. I do not have one piece of document, your signature on the termination order. That is where I lapsed. But other things, everywhere you like, you suppress that fact.
No.
Even the accommodation is not brought on record.
What about the judgment, they ordered for examination of the matter? Thereafter, what you have done?
Thereafter, we passed a speaking order, which is under challenge in this petition. After
This
that,
termination.
oh yeah, no, This Honorable Court directed us to look into the matter.
Yes.
We looked into the matter.
Yes.
We passed an order whereby we denied them the benefit of back wages. That order Lordship will find at put this letter. Representation order even passed in Honorable. The order is in that order to assistance.
No, in this
termination.
writ petition only 18/5/92 termination order
No,
is
no,
being
no, no, no,
put
no.
to challenge.
No, what they are doing is 18/5/1992. They are now trying to say on the ground that we did not even receive a notice
It's
for.
okay. It's okay.
Not only that,
Your whatever. Have you challenged that order?
Yes, yes,
termination order we challenge.
Where? Which
No,
one?
not the termination of the order. of
9573.
1992. You have challenged.
1992.
The order passed by the authorities after the order of this court in the earlier round of litigations.
We have not-
Yes, yes, it is challenge. It is under challenge in WPC 3288 of 16, which I was referring to.
Yes,
Yes.
first repetition.
3288, they challenged it.
I'm challenging thereafter they file an affidavit by annexing
Okay,
that
okay.
document, so thereby we challenge.
Thereafter, they challenged 8992.
Hold on, wait a minute, hold on.
150
No, no, hold on. My lord, time is over, my lord. So I'm simply to
No, 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 I have not
to
finished.
submission I am giving, and as your lordship will do it, I
Lordship
don't
will
know.
find at page 152.
It's okay. Just
Or specific.
Regularly, my lord, again and again, your lordship pass an order whether
sir,
termination
just wait.
or not. Because of
Please.
that, my lord,
Page 152, if Lordship has, which was under challenge.
Hmm.
Read the Honorable High Court order dated 27/4/12 in WPC number so and so. The report submitted by DEO, also seen other relevant records. Honorable High Court, by its order dated 27/4/13 passed in WPC 565, dispose of the case with direction to the authorities.
yes.
to execute.
There is what-
My
So
lord,
there,
just two
we
lines
had
I am going.
again said that a show cause notice was issued. You replied. Yet they come before this court to say that no show cause notice. Is that not, my lord, a lie? Is that not something which depicts the
That's all. Why you are rushing? We have time. We have 10 minutes.
My lord,
We can sit up to 5 o'clock.
my lord, they
5 o'clock. Don't worry.
My lord, they file an affidavit, my lord,
Yes.
in WPC number 9573, my lord.
Hmm.
My lord, so many orders your lordship has passed, my lord, to submit the record of the termination order. They stated in page 201.
Hmm.
201 state, paragraph 14.
Yes.
The answering deponent have to beg to state that so cause notice were issued to the petitioner and reply of the so cause notice not being satisfactory. The petitioner were terminated from service. So cause notice to termination letter were duly served, so and so, so and so. But they did not say anything, no date for when and how they served the termination order.
Page.
Page 201, paragraph 14. Just some 3 lines.
No, no. In
First case, my lord,
First case.
my lord, 19
95.
case, my lord,
9573.
9573. They were never, I am never saying so cause notice what issue. This is our life. They never says again and again. Page 201, paragraph 14.
201.
So, yes, my lord, answering deponent Hamlu begs to state that so cause notice were, paragraph 14.
14, yes.
Yes. Beg to state that so cause notice were issued to the petitioner and reply of the so cause notice to not being satisfactory, the petitioner was terminated from service. So where on what date they even not mentioned, and your lordship, so many orders are there.
That is only your case.
You know, number one, I
That's
am
all.
going to one by one.
Hmm.
Next, my lord, fact is that, my lord, your lordship, just 2 minutes, my lord.
Hmm.
Facts of this in the year 1992,
Hmm.
they in the year of 89, my lord, more than, my lord, 700 teachers were appointed, 752, and some of the petitioner were terminated. Some of the teachers were terminated. Those who teachers were receiving termination order, they came before the Honorable Court. And Honorable Court set aside this termination order. And those who are not terminated, we are not terminated. So thereby, immediately in the year of 1992, we are not coming. But those who have received termination order, they came before this Honorable Court. I annex, my lord, please make a list. Page 188. What about written? Page 188. This is the judgment is clearly said, my lord. The case of the petitioner is that they were appointed in various school and stated so annexer so and so. Petitioner also joined their duties in respective school. However, respond number 3 issued so cause notice.
Which order that is?
Page 190.
Which order?
Order
Order.
civil rule, my lord, civil rule number 2633 of 1992.
2633.
At page 188 in my writ petition, my lord.
Yes.
My lord, the case of the
Order dated?
order dated 20 judgment the hearing dated 24/7/95 and judgment dated 24/7/95. Page 190, your lordship. Yes, my lord. Entire facts is there, my lord. The case of the petitioner is that they were appointed various
No, by this order, those who have been terminated.
those who were received termination order, they came before the honorable.
And
Those who are not received, they are not coming.
Then court.
Court said to say that termination order, my lord.
Then what happened thereafter?
They are receiving salary, they retired peacefully.
As a regular,
Assistant teacher,
as a
regular teacher. And thereafter, one termination was not received. They stopped salary, and thereafter, your Honorable High Court dismissed the Dulu Davis case. She go to the Supreme Court. Supreme Court allow Dulu Davis case is there. I'm given the judgment, my lord. Again, I will also pass. And your lordship is what they stated in 95 your Honorable High Court order. Please make a list, page 190. The case of the petitioner is that they were appointed in various schools stated in Annexure 10. Petitioner also joined their
It's
duties.
okay, Abanas.
So and so, their appointment should not be cancelled. The cycles, very important. Annexure 8, cycle style notice keeping some blanks, which has been filled in by hand, was served on the petitioner. The petitioner, in reply to this notice, so cause, but respond number 3 found their reply not satisfactory, and accordingly dismissed the petitioner from service on the ground mentioned in annexure. This is also a cycle style copy keeping some blank. These are same, my lord, which were filled up by the.
You just read the last
I have heard so normally
last
when
paragraph.
Paragraph number 5. Normally,
last paragraph.
no, my lord, this is very important.
No,
Normally,
it's okay. I've read it there. For your only. for
I
your-
therefore set aside the annexure 9 under memo number, same memo number 651692 dated 18/5/92, and also order mentioned in paragraph 3 writ petition under memo number 6104-137, same dated 13/5/92, and 6430-516 dated 18/5/92 issued by the Deputy Inspector of School Dhemaji. Respondent terminated the service of the petitioner, and they shall be deemed to be service. They shall be taken back to their service within a period of 1 month from the date of receipt of the order. Petitioner shall also be entitled in all consequential benefit, including their back wages. They received the termination, so they can.
Had you been served with a termination order,
No,
you would have approached this court. Therefore, you are relying on this.
Yes, my lord, because we are not terminated, we are not received termination order.
Same thing. What I'm telling, what I'm trying to tell you.
Yes,
Same
ma'am.
thing. You
Same.
are relying on this judgment
Yes,
because had there been a termination order against you in 1994, which
Yes, 92.
had it been served on you, you would have approached this court and got the similar relief. Therefore, since there's no copy was served on you,
Yes, my lord.
it is deemed not terminated.
Yes.
Though the
This is my
notification,
humble submission.
but you have to reply.
But one thing is
that they have admitted termination order is issued, so cause notice was issued, you have replied, found it not satisfactory. But then they have no record to show that on which date and how you have been served.
No, this
But
is-
courts remember that you have said
The
you
date
have
is
not
there, my
done
lord.
it.
I do not have the record. I'll show the date.
Yeah, date is there, but no, how you have served, when you have served.
that is
That is
That is
and
They have
Dulu
admitted,
Davis
they have
case.
fairly admitted. Just wait. Now you have to tell us, only you have to reply was that we have understood. You have suppressed the material facts.
My lord,
This is not the so far as the so-called notice.
yes, my lord.
All along, your case begins with that you have not been served with any so-called notice. All along.
My lord, it's
Even if the reply and everything was brought on record, you didn't say anything. You are only again harping on the weakness of the authorities. There's no explanation
My
that why you have said that you have not been served with the so-called notice. Despite the fact that you have received the so-called and then you have submitted the reply.
That is, my lord, on record. We cannot against that.
So these are the things.
Yes, we cannot
It is not
ignore, my
simple
lord.
as
This is
the-
a record they
what you are
submitted. my
asking.
lord. But that set aside in 1992 in the 90th order, my lord, that order, my lord, they also served a copy of the so-called. They replied it,
So
and
you
thereafter
have-
termination
so
order, they
therefore-
challenge it.
Therefore, petitioners have also suppressed the fact that so-called was issued
That because of that
and
earlier
reply
occasion,
was filed.
I am not in the
At the
council
same
in
time,
America.
the facts remains that termination order was issued, but at the same time, facts remains that they are not able to show that whether the termination order was served on you.
So thereby meaning that
So these are
95
the things.
these are,
Court
and
will
like
examine
those who are received termination, they came before the
whether
order.
your act of suppressing this so-called notice and reply.
But they
would
also
dis-
suppressed. They
would-
also
would-
suppressed. They did
would-
not.
No, would disentitle you to any relief from this court. Will examine
On the other hand, my lord, their officer.
and non
My lord.
thereafter,
Uh,
or whether non-furnishing or non-service of the copy of the termination order
mm.
amounts to, not termination.
But they also suppress that director, deputy, and the DO says that we are not terminated.
Sorry,
That
thereafter-
later,
thereafter-
they did not deny.
Sir, thereafter, this court has intervened,
Right.
directed to re-examine.
Yes.
You have shown that.
My lord, that
No,
later.
they have shown that. In
2000
earlier proceedings,
No, I am not on that. I am.
you have said that the director or the authority,
My
the
lord.
district elementary.
Yes, as well as
Inspector.
director, stating that we are not serving termination
On
order,
consi-
but they did not
no,
reply it.
on
my lord. They
consider-
also suppress.
On consideration of that,
My lord.
your submission in earlier litigation, there is a direction.
Right.
Whether it's a disputed question of facts, you examine.
My lord.
Thereafter, this order was passed and you have put to challenge in the next district,
My lord.
the 2016
My lord.
other writ petition.
My lord.
So there is no question of separation on behalf of them.
Because of
On
that,
their- on their part.
but that letter was annexed in the next 19 writ petition also. They did not say anything. Director as well as DO, that is also suppressed. 50-50.
I think
50-50, my lord.
My lord,
Because of that is very important letter.
that you have already placed before the court. Court has considered that and direction was passed
But
that you
my,
examine.
my lord. But
is
that,
what- is
that
recorded in
examination,
which writ
and
petition?
other
my
hand,
lord, the other one.
566 of 2000.
suppose, my lord,
5635 of 2007.
Yes.
Disposed
my
of
lord,
in
but one
15.
thing is that if you go to the, because of his challenging in termination order, that termination order, suppose they, yes, my lord, so cause was issued. Petitioner replies so cause. Reply is given in different issues, but they did not consult. That they blanket order, you terminated, you are not
Do you have
satisfied.
any case law? in
So
your
today,
support?
today
No,
I am
not
some.
today. We are closing it today. If you are not submitting today,
Hmm?
nothing can be done. If you are not submitting
My lord.
any placing any
My lord,
case,
placing in Dulu Devi case.
then
Dulu
I-
Devi's
I-
case.
that option must be-
Dulu Devi case already
It's there.
given. Same
No,
appointment,
no.
same, my lord.
Do you have any case law that even if termination order is passed, if it is not properly communicated or served on you,
Yes, it's just when I will give him my lord tomorrow, my lord.
tomorrow,
I'll give
You
my
have
lord because
to-
of one
you-
very important judgment is there.
tomorrow, Mr. Bora,
No, tomorrow no, my lord.
tomorrow you come with me
No.
to Itanagar.
No, sorry. My lord,
We'll have
it
the-
is just is
in the
very,
dinner
very,
in the-
very
dinner.
important Supreme Court judgment. I have there, my lord. Today I am due to some. internal noting cannot be treated as a communication.
It's not internal noting.
Not only that,
This is a
if
termination-
this
termination
termination
order.
if this termination order in file,
Which
that
they have
cannot be
said,
treated
which,
as communication.
which they have not said, which they have said it has been issued.
By
But the
the-
only
Sharp part
receipt
is that.
difficulty is that
Sharp part.
whether it has been received or not, they are not able to locate the
Yes.
records
And even-
even is of 1992.
Even in that writ petition,
30
they
years
stand
back.
is, I do not have a show cause notice or a reply to the show cause notice. Is just
As,
standing that
as your
petition.
lordship, my lord, I cannot
And
say.
one thing just,
You just serve
As
it.
your lordship, you can
You
write.
just give it back today.
Today, my lord.
Or Boro,
Uh,
you submit it on Monday.
Monday, yes,
You
definitely.
just
Monday.
communicate it.
What is communication? But clearly
No,
stated.
no, that you don't have. You only anyway, whatever you want to. It's a certain law. It's very clear.
Yes.
What I wanted is that in case if it is not served,
My lord.
is it amounts to
Not communication.
not communication?
Deemed to be not
It's
communication.
not amount. It's obviously it is not. Is it deemed to be
Not communication. Is
not,
that
not
yes.
terminated?
Yes, yes. Yes, that's order is there. That is the one line is there that just where the internal noting and in the kept in file cannot be treated as communication. This judgment I will give.
We have issue numbers.
That is something.
Anyway, but one thing only, just one sentence.
No, my lord,
He
I
said
will
the
also
termination
close it, my
order
lord.
does not have a date.
Huh?
Page 202, para 16, 18/5,
No, no,
And
1992
my
is the
lord,
date.
close it, my lord, as your lordship, my lord. I
Same,
cannot.
same, huh? So the hard disk
Oh, lord, you can-
and Boro, now you concentrate. So, Sachin, huh? Two and three. Then rest. Four and five. And then we just record all this. It's already. Ah. Earlier. That's,
তুমি হলো নাই পৰা নাই।
Nine, five, seven, three.
সন্মানে গুচি গ'ল।
Hearing concluded. Judgment given.
মাছ চলে